Okay, ladies and gents, let's get started. So, good morning, Sunday morning. Sun is shining here in Joburg. Hope it's the same for you out there in Durban, in Cape Town, and all the other areas. Let me just jump on here. Who is with us this morning? Putty says good morning. Daryl says good morning. Carol, hope you're all ready to rock and roll. We have got some awesome speakers today. Let me move away from that. Let me cut that out for 2 seconds. So in that chat box, please let me know who is with us this morning and who had a good day yesterday. Who had a really good day yesterday? Let me know, ladies and gents. I think you all learned a lot. I mean, we had about 50 questions at the end of yesterday, and the same is going to happen today. So what did we actually cover yesterday? So we went through the 5 steps of the signature solution. Step 1, 2, 3, 4, and 5. And today we're going to complete steps number 6, offer to purchase with Leonora Swart, talking about the importance and the understanding of that OTP, which then moves us into refining systems, deal management, and then repeat and grow. And I want you all to take part today, like you did yesterday. In fact, we do have a winner. I asked my team to look at the chat box to see who was interacting the most. Who is going to win the most valuable prize, the Property Academy mug? So the winner is, ladies and gents, give me a drum roll, everyone. Give me a drum roll. The winner is Cholton. Can you all give Cholton a round of applause? Cholton, well done, buddy, on winning that. I will be sharing the main prize in a few minutes. Now, by the end of the day, remember these slides from yesterday, the housekeeping rules. The goal from yesterday morning until 3 o'clock today is that myself and my speakers and my team are going to start shifting your mindset as to how you approach and how you look at property. And some of the housekeeping rules were, let's have some fun today. It'll be so boring if all the speakers just spoke like this. And let's have some fun, interact, and remember to ask loads of questions. Have an open mind today. You know, some of the stuff we're teaching is not conventional. Some of it is, some of it isn't. But have an open mind, let the information sink in, and then take action. And at the same time, can you all just give us 110%? Myself, my team today, Ati, Dave, Nico, our speakers, Leonora, Robin, Dave, Ross, we've got quite a few speakers coming up. They're all giving you 110%. So give us all your focus today. And remind me, ladies and gents, who's going to win this today? I think someone Googled it yesterday and it came up like over 3,000 Rand for this cash flow game, if you all remember. And you cannot buy this in any shop in South Africa. So if you have kids, if you know of friends, family members who do have kids, it's a great game where you start to change the youth's mindset as to how they look at money, the doodads, the green tokens versus the red tokens. So who wants to win that, ladies and gents? In that chat box, let me know who's going to win. It's a great prize. Cool. So what does today look like? So I'm just doing a quick recap of yesterday, but very quickly, we will go straight into Leonora Swart, who'll be talking to us about the offer to purchase. I'm then going to bring a guest speaker on for about 15 minutes, and we'll see who that guest speaker is. And then we'll have a break after that, and then we bring in Robin Booth, talking about refining systems. You as a property entrepreneur, as you scale, as you buy more properties, you're going to have more and more admin. How do we start to refine? What are some of the tech tools we can use to refine those systems? And then we've got Dave coming online to talk about running the numbers. A lot of investors, beginner investors, don't quite know how this works. Even advanced investors don't always understand how to run the numbers. So there's a masterclass at 12:15. I will probably get a break in there as well. And then we get to point number 8 in the signature solution, which is deal management. How do you manage your property? How can Preferential, which is one of the companies in our ecosystem, how can Preferential help you scale as a property entrepreneur? And then, of course, the Q&A panel. So just like yesterday, please put all your questions in the chat box. My team will copy and paste it into a spreadsheet. I just ask you that if you can give a bit of context when you ask the question, because as the speakers are speaking, you'll ask the question directly. But remember, we copy and paste it into a spreadsheet and bring it up later in the day. So just try to give your question context with the frame of mind. We answer the questions at the end of the day, not straight away, okay? And then we're going to be doing a Q&A panel, and then I'll be giving away the cash flow game. So if you want a chance of winning that, you have got to be active on that chat box today, okay? And just like yesterday, the outcome is I want you all to get clarity on the clarity on the signature solution, understanding those 9 steps. Upskill your knowledge today. Promise you, through Robin Booth, Leonora, Swart, Dave, and Ross, there's probably more content today than there was yesterday, which is great. And remember the 2 different ticket prices I spoke about yesterday, 500 versus 1,500. For those of you that did pay the 350 or 500, and you do want to walk away with all the recordings, including the Q&A, the templates, my goal planning documents, and everything else our speakers are giving away, you just need to upgrade to the higher ticket price if that's what you want. You'll get your questions answered today. We answered like 50 questions yesterday. And yes, access to discounted products and packages. Remember your 2 different options. If you didn't take a photograph, take a photograph of this and just have a chat to Alani or Daniel today. So this was option 1, which is the fundamental course, the 6-month professional membership where you get to join the mastermind. The offer to purchase course, which is brand new. You're the first audience, has literally gone live this weekend. You're the first audience to actually hear about it. You've then got the advanced consultation with Bruno and Shirley Boy with Intergen, and a one-day wealth builder ticket in Cape Town, Durban, Joburg, wherever you are. And the second option, all we've done is built the 2 line items onto this, which is the group coaching and the blueprint. Remember, the blueprint is point number 3 in the signature solution. So you must just decide where you fit in and what you're looking for. If you have questions about how does group coaching work, how does the blueprint work, remember Alani is here for you today, and Daniel. Daniel's joining us around lunchtime. But remember, the video you're watching underneath it says talk to Alani or talk to Daniel. If you're getting stuck and you can't get hold of Alani or Daniel, just put in the chat box, I want to speak to Alani or Daniel, and they can help you choose whichever package you are looking for. Or perhaps there's one thing in there that you want to take out and you want to run just with the membership, for example. We can be flexible for you. Is that all good, ladies and gents? Let me know if that's thumbs up. Let me know if we are all good there. Let me know. Is it all good? Okay, so just checking that we are all good on time over here. I'm going to bring Leonora up in a minute. It is 9:15, so I just wanted to get through the housekeeping with you, recapping on yesterday, the signature solution, where are we? And we've got some great speakers coming up. As I said, I'm going to bring Leonora up in a few seconds. Leonora, from there, the guest speaker comes in, Robin Booth comes in, Dave comes in, and then Ross comes in. It's literally going to be jam-packed, which is awesome. And yes, we'll talk about the offer to purchase course later on. So I'm just going to see, is Leonora out there?
Yes, good morning, Andrew. I'm here.
Good morning, Leonora, and thank you for waking up so early on a Sunday.
You're more than welcome. Thank you for having me today.
No, it is my pleasure. So, Leonora, I've been working with yourself and Bruno for a number of years. And you've helped us with so many different types of offer to purchases. And I was saying to students yesterday that the average person thinks of an OTP and they think of an agent and they just think of the standard OTP. But even with estate agents, they all have their own offer to purchases. And I was saying to people, but what?
Okay, Liku, shall I continue because it's the last day? Okay, guys.
Yes.
Okay, let me go ahead. It seems like we've lost Andrew there. Niku, can I share? Niku? Okay, thank you. All right, good morning, everyone. I hope you can see my screen. Niku, can you confirm? So, good morning. So, one is not supposed to have a piece of steak for breakfast. This morning, 9 o'clock, you are having me, which is a piece of steak so early on your stomach regarding properties, the contract, the OTP. So this is me. I'm Leonora Swart, and I'm a senior associate at Bruno Simão Attorneys. I'm located at the Brooklyn branch. I am the conveyancer there, and I attend to all the property-related matters. So my mandate today is to talk to you about the offer to purchase, the deed of sale. So my take on this is as follows. So to sign an offer to purchase is a daunting experience. I do understand that. People are scared to make offers because they do not understand the contract. So that is why it's important that you know the content of the contract. Remember, just as Andrew mentioned, he said that, you've got estate agents and each agent has their own contract. Yeah, that's fine. But the basic terms and conditions are mostly the same. I would say go so far and say 90% the same. You need to know your offer to purchase and the terms and conditions. So I cannot convey 28 years of experience today to you, but I am going to see if I can make you a little bit legal savvy, that you are more confident to sign that offer to purchase, that you are more confident to make that offer. To purchase property and to go out there and make your offer, I always say to the people, you have to be brave, but you have to be informed. So I'm not going to bore you with legal jargons and stuff like that. So basically, the buying and selling of land is regulated by the Alienation of Land Act 68 of 1981. Okay, basically what it says is you cannot purchase and sell immovable property if not in writing. It has to be in writing. There's usually also a clause at the bottom of each and every contract that says no verification of this contract will be allowed unless it's reduced in writing and signed by all parties. That's why people, everything has to be in writing. You know how people change their mind. Yeah, but you said, no, I cannot remember what I said, but I don't think that is what I said. We put everything in writing. So what is important that has to be in a contract, just to make it legally and binding as well. So first of all, yes, in writing, you can use the estate agent's contract, and I'm going to try and educate you today what to look out for in a contract or different types of contract. The parties must be identified. So usually you as the purchaser would make the offer, so you will already put in who the buyer will be. Then when you make the offer to the seller will complete their details. But there must be a seller and a purchaser. The property description is important. Otherwise, you cannot leave that portion of the contract blank, and it must be signed by both parties. The fact that the contract is not signed by witnesses does not make it an illegal contract. Okay. So, clauses that we have to consider when making an offer to partner.
Apologies, Leonora. Can you just share your screen again, please? It looks like your screen is not shared.
Okay. Where are we now? Do I have to go? Do you see it now?
Not yet. Just look at the bottom of the screen where it says share screen, and then just select your screen.
Okay, sorry. So I've been talking without the screen up to now.
That's why I quickly just wanted to fix.
Share screen. Hello. Okay, there's a share screen, people. There we go. Okay. Entire screen. Share audio. Okay. Okay, so this went much easier when we did the dry run, Niku. Where do I go? Choose what to share, the entire screen, but it doesn't give me the option to share. Okay, let's just do this again. Nico, are you sure that I can do this? Because there we go, people. Oh, yes,
Yep.
I don't do it.
Okay.
Okay.
Now,
All right. Thank you, Niku. Luckily, I was not at slide 5 already. So are we now here? Are we there?
Yes, Leonora, that's good. Just make it screen presentation, yes.
Can you see me?
There we go. Perfect.
Okay, that's me, people. Offer to purchase. Okay. Are we now there? Okay. Thank you. Okay. So the clauses that we have to consider for the offer to purchase. So first of all, the parties. I did say to talk to you about the parties. So now you might ask me, in whose name must I purchase? I'm not the expert on that. I can give you the legal consequences left and right. But when you make an offer for investment purposes, you need to talk to Chili Boy or your accountant to advise you as to whether you should purchase it in your personal capacity, whether you should purchase it in a PTY or in a trust. They will advise you on that. As I mentioned, the property description is important. The purchase price, these are small stuff I'm not going to talk about today necessarily, but the purchase price, so that is the offer that you are making. That is the purchase price. There's not really much to say about it. But what is of importance about the purchase price, which we are going to discuss, is how are we going to pay the purchase price? Subject to what is the purchase price payable? A deposit. So people, there is no rule, and there's also no fast rule that says that you have to put down a deposit. That is not the case. You do not have to put down a deposit. So you can make your offer subject to 100% loan. Or if you've got the cash, to say that you will just deliver guarantees or pay the purchase price to the conveyancer within a certain period of time. All right. What we are going to talk about today is this are suspensive and other conditions, because that is, for me, it's when people send me a contract and say, just look at the contract. This is the first thing that I look at, is what is the suspensive conditions and the others. Compliance certificates, we will talk about that also today. Those would be the certificate of electrical compliance, gas certificates, electrical fence. If you are purchasing at the coast, Cape Town, plumbing certificate, coast entomocologist certificates, those are by bylaws compelled to be delivered. We are going to talk about occupation versus possession. So occupation is something that you have to be aware of, and don't just sweep that under the carpet and think it goes easy. It does never go easy. Foot stewards. I'm not going to touch today on foot stewards. A little bit, I will talk to you about defects, but foot stewards basically means as is. You are purchasing it as is, but it is the seller's obligation to disclose all the defects. If the seller knows about defects and he does not disclose it, then the foot stewards clause will not protect the seller. Okay. Conveyancing attorneys. So it is the seller's prerogative to appoint the conveyancing attorney. That is the practice in South Africa, although the purchaser pays the transfer cost. So now they ask, why? If I'm paying as purchaser the transfer cost, why can't I not choose the attorney? It's because it's the attorney's obligation. It's my responsibility as conveyancer to act in the best interest of the seller. From my side, I do try to be not partly. I do not say I act in the best interest of the seller or the purchaser. I try to make the deal work at all costs, to make it happen for all parties. But by description, it is the conveyancer's responsibility to act in the best interest of the seller. So what is transfer cost? So people, do not get confused between transfer costs and transfer duty. Transfer duty is the penalty which you pay if you purchase property. Okay, that goes to SARF. But the exemption is up to 1 million rand. So people get confused. They say, oh yeah, but the property I'm purchasing below 1 million, why is there transfer cost? Somebody has to pay me to put the property into your name. That is transfer cost. Transfer duty is payable above 1 million rand. And it goes like this. There's like a 0 on 1 million, then there's a 500, then 1,000, and then there's like a 6,000, and then there's like a 50,000. It just goes a very steep curve. And also that's of importance is the breach of the agreement. What happens if you breach the agreement? What happens if you or the seller or the purchaser breaches this? Okay, so people, here's a piece of steak. So why am I now referring to types of agreement? For me, it is important because it is material to the agreement as to in which direction we are going to move with this transaction. So you get conditional agreements and unconditional agreement. Okay, so don't get confused. If I say an unconditional agreement, that means it's a piece of paper with no conditions, okay? If I say conditional and unconditional, it mostly refers to the paying of the purchase price, okay? Contracts has a lot of terms and conditions. All right, so let's just be on the same page. You don't get a contract without terms and conditions. So just now, so my reference to conditional and unconditional is specifically with respect to suspensive conditions and payment of the purchase price. Okay, so let's go to the easy part, the unconditional agreement on the right-hand side. So an unconditional agreement is a straightforward purchase. It says, me, Leonora, is buying from Nico Deploy for 700,000 Rand cash. The purchase price will be paid by the 30th of June, and all other conditions is applicable, such as rates and taxes will be paid by the seller. The seller will deliver, will pay all the clearances. He will deliver certificates. I will pay the transfer cost. Vacant occupation will be given. All of those conditions are embodied in the contract. But there are no additional conditions in the agreement in respect of the payment of the purchase price. It's not if I sell my property, if I get a bond, subject to, or I must get an investor in, or stuff like that. All right, that's unconditional. So this is a cash offer, in other words. So what happens now if Leonora, myself as purchased, the contract stipulated that the purchase price is to be paid to 30 days or by the 30th of June, or the guarantees are to be delivered. What happens if I do not pay the purchase price? The contract is still valid, it still stands, but the conveyancer has to place the purchaser on terms. That is where the breach part comes in, the breach clause that says, should any party fail to comply with any term of conditions of this agreement, the party in default will be placed on terms, and then that contract that you've made, that offer, will have a time period in it. 7 days, 14 days, 21 is ridiculously long. Depends on a lot of stuff, but it's usually about 7 days, maybe 14 days. Okay? And to comply with this agreement, failing which, the seller has the option to either force compliance, that would be with a high court order to compel him to proceed, or cancel the agreement. So the consequences of this is that if you are the party in breach, and me, Leonora, and I did not pay my purchase price because it was a cash deal, and I failed to comply within the 7 or the 14 days, and it is cancelled, I will be liable for the attorney's wasted costs, and I will be liable for the agent's commission if there is an agent involved. Okay? That is on that side. All right, so let's go to conditional agreements. So there are special terms and conditions that you can put into the contract, additional to those already typed in, and then you've got suspensive conditions. So we are going to touch on suspensive because that is super important, people. So let's just look at special conditions and terms. Okay, so on special terms and conditions, those are additional conditions that was completed in the offer. Now remember, whether you are a seller or whether you are going to purchase, it has to be complied with prior to registration. So now you're asking me, Leonora, so what are special terms and conditions? Those would, for example, be, you have, okay, Leonora's making an offer to Nico Deploy for 500,000 Rand, but the property, this is a good value, but there are certain defects. I saw that the one window in the dining room is broken. There is a damp problem in the hallway that is coming from the bathroom on the other side. I want those repair prior to registration. So what did I do when I started it? What did I say when we started? People, everything has to be in writing. And please be clear. I once got a contract. It says, the window is broken. There's damp in the hallway. So I phoned the agent. I said, okay, so what does this mean to me, the conveyancer? Just remember, when you complete conditions in a contract, the third party there on the outside, meaning the conveyancer, hello, has to understand what is the meaning of this contract. I was not involved as conveyancer with the signing of this contract. I do not know what was agreed, spoken. So I found the agent. I said, okay, so what now about the broken window and the damp in the hallway? What now? Must I just take note of it? Does it mean the purchaser is aware of those defects and it falls under the footsteps clause that he is purchasing as it is? Or does it mean the seller has to repair it prior to registration? Can we just be clear on this? And that is the problem with terms and conditions that's written in. I don't say don't write it in. Please, people, everything has to be in writing. But just be clear on what is the intention. So, for example, if Leonora, myself, made the offer to Niku and said to Niku, this has to be repaired, then you say, the seller will repair the following defects prior to registration. Double point number A. Fix broken window pane in dining room. 2. Have a specialist to treat the damp in the hallway and deliver, for example, a 5-year or a guarantee certificate by the service provider there. Stuff like that. Okay. So be clear as to what is happening with these terms and conditions. Another special term and condition would, for example, be, I think I might be talking about it later, is tenants. So some contracts does deal with tenants. Some agencies has a clause, contracts has a clause in that says tenant and occupancy, then it will, for example, deal with the tenant. That says, there is currently a tenant in place. It's got a 6-month lease agreement, which is expired. So where are we now? We're on the 12th of June, which is expiring the 31st of July. Which means that you can take occupation on the 1st of August, or notice will be given, stuff like that. But people, never assume on a tenant. Never. Complete the conditions. Okay, so let's just talk about notice to the tenant. So you cannot expect the seller, when he's got a good in place, paying religiously his lease agreement, a rental amount, you cannot expect from the seller to give notice to that tenant on signing of this agreement. Okay? Because for 2 reasons. One, if it's an unconditional contract, a cash offer, I would say notice must be given once you've paid your purchase price, because then it's a done deal now. Secondly, if it's subject to obtaining of a bond, we first need to get a bond. This contract is still not enforceable. It's binding to all parties, yes, but it's not enforceable as yet because there's no bond in place as yet. So usually what I would say is to say, depending now also on the terms and the conditions of the lease agreement, because, I hope I'm not interrupting myself too much, because remember, the seller has an agreement with the tenant. You cannot expect from the seller to breach his agreement with the tenant, for example, if his agreement stipulated 2 months' notice. You cannot force him and say, I need you to give 30 days notice to a tenant because I would definitely like to move in the 1st of August. You cannot do that, people. That is why it's important. I'll most probably touch on it again or just refer to what we've just spoken. That's why it's important that when you go and view a property and there is a tenant in place, that you ask for the lease agreement. Do not accept what the agent tells you. Do not accept what the seller tells you. Well, he is a party to the agreement, but mostly that will be on the other part. But ask for the lease agreement, the written lease agreement, that you can see for yourself what is written, how long, how much, where's the deposit, and. Because if you are going to take over that tenant, you are bounded to that lease agreement. Okay, so a lot of said there. So are you with me, guys? All right, let's talk about suspensive conditions. So this is the difficult part. So a suspensive condition means the following, that the contract is subject to the fulfillment of this specific condition. The contract is binding to both parties. They are legally binding, but it's not yet enforceable to proceed with. Do you understand what I'm saying here? Until this condition has been met. So usually there are, so I do understand that our attendees today are property investors with the idea of purchasing property. So in your instance, you will most probably not now purchase an investing property subject to the selling of your existing property. So that's not the aim here today. But maybe you are in a position that you want to resell a property, maybe one that's not as profitable as you thought it would be, and you would like to resell it. So then there are usually two vital suspensive conditions. One is the obtaining of a bond, and then two, what we are going to talk about, is the selling of the existing property. That's why I'm saying that you most probably not going to sell your existing property, but if you're in the position of a seller. So those are mostly the types of conditions. Oh, and the other one that we also use as in at the Property Academy is the due diligence. The due diligence is of importance. That's also a suspensive condition. So the contract is subject to the fulfillment of the agreement. The contract, what happens with suspensive conditions? It lapses automatically with non-compliance. It becomes null and void. So I don't even have to send the purchaser a notice saying to him, dear sir, dear Mr. Purchaser, in terms of the contract, you were to obtain a bond by the 15th of June. I know that it has not yet been obtained. I am placing you here on 7 days term, breach agreement, a breach clause, to provide me with the proof of payment, failing which the seller will elect to cancel. No. That is not how it works. If the 15th has come and gone, it has lapsed, it's null and void, I don't talk to that purchaser anymore. So how do we keep this contract alive? Two ways, or what can we do with that? One, prior to the date on which the contract lapsed, you have to be mindful of that date. You must put it in your calendar. What date do you have to comply with? We can, in writing, extend the time period for obtaining of the bond. So what we usually do, could they do that they can do it from their side. A conveyancer can also do it. The agent might also do it. You approach the agent and say, listen, I am almost there. I did have some challenges with the obtaining of my bond. Things are not always going as smooth as we want it to go here with the banks. They're also inundated. But I need another 10 days, please. Then we just extend the time period. In writing, seller and purchaser, they both sign it, and the contract is extended. So the suspensive condition is kept alive. People, suspensive conditions cannot be vague. It cannot be open-ended. It must have a time period. So that's why a contract must say, subject to obtaining of a bond within 30 days from date of this agreement, or by the 31st of July, for example. All right, it cannot be open-ended. It actually places me, I've had, you will not believe it, 2 contracts now that I had to place a purchaser on terms, and I looked at the contract and there was no time period for obtaining of a bond, and I thought, oh my gosh, so now how am I going to do this? Then we had to fall back on the time period for the delivery of guarantees, and I had to place her on terms to say, okay, but that time period has now lapsed for you to deliver guarantees. But the fact is that if there was a time period, it could have lapsed in null and void, and we could have proceeded with the other contract. But the contract did not have a time period, which means I first had to place her on terms to be in breach, and she gave the bond approval through in time, and the first contract proceeded. Although in this instance, my second offer was 100,000 more. So please, there must be a time period to suspensive conditions. So let's just cap on that. So for example, if you've got a subject to a bond, give yourself enough time, especially if you're going to purchase in the name of a PTY to be registered. Give yourself enough time to register the PTY and to obtain a bond, because you cannot start with the bond application before the PTY has been registered. Okay? So if you give yourself a short time, you are going to run into trouble there. Secondly, okay, so if it's subject to the selling of an existing property, maybe your purchaser, I don't know, just don't make it too long. If it's yourself, you can maybe make it long. If you're the seller, don't make it too long if you want to sell it to somebody else. And another one is the due diligence. So I know that Niku and those people that help you with the investment and stuff, they will advise you on the due diligence. I would say a 7-day due diligence is a good period. The sellers are not always so excited about it, but they've got their way in convincing the seller why you want to do the due diligence. So I would say you don't really need 7 days. Maybe you just need 5 days, unless obviously you want to do a rezoning and stuff like that. Then you will have to put a longer period. All right. So what also has happened in some of our transactions is that the contract has actually lapsed because the seller did not want to give an extension of time, but he did not have other offers on the table. So the bond was then approved a few days later. Then we go back to the seller and say, sir, we do understand that the contract has lapsed. It is null and void, but we've got now a bond approval. Are you willing to proceed? And then they say, yes, we are willing. And then we will do a reinstatement agreement whereby both parties agree that we are reinstating the contract which has lapsed on the same terms and conditions as in the initial contract. Okay? All right. So my last choice, my last wise words on suspensive conditions, choose or use the word suspensive wisely. Please do not make it, people, do not make the contract subject to the repairing of the window pane in the dining room. Do not do that. It's not going to happen. You cannot make that a suspensive condition. You cannot. It's just an ordinary condition. Do not use the word suspensive loosely. It is a very scary thing to do that way, because you are going to have your contract lapse without even the intention. Use it as an exit clause, okay? An exit clause, for example, a due diligence. You first want to look at the property, do your footwork on the property, see if it's a good investment, see what is your return on investment if you're going to do multi-letting, what. Do for exit clause. Or I would do a lot of work for speculants. So sometimes they make an offer and they don't want to lose the property, but they would like to resell it again. Maybe we're going to talk a little bit about back-to-back transactions, resell it on, but they don't want to take out the finance. Then they would make it subject to obtaining of a bond. So use the word suspensive wisely. It must be for a material term of the agreement. It must be like a deal breaker term of the agreement. You understand? Such as due diligence, obtaining of a bond in our instance, and maybe, I don't know, if you want to make an offer in your private life in respect of purchasing another property and you want to sell your existing property, selling of an existing property. And please, as I mentioned, the time period must be completed. All right. I'll have to talk faster. So let's talk about making a private offer. So if I say making a private offer, I mean making an offer where there's no estate agent involved. Because estate agents, when you work for an estate agent, they don't like using other people's contracts. Although, Niku, those people, they're very clever. They've got a way in convincing their agent to use their contracts, which is very comprehensive and very complete. But the most important part is use your contract, a contract with which you are familiar with, that you understand all the terms and the conditions in it. So conditions in most of the contracts, so I'm going to run through this one fast, is, for example, the seller to deliver required certificates, those compliance certificates that we spoke about. For example, the electricity, the gas, and so on. The seller has to deliver it. But people, this is not fixed in stone, set in stone. If you think about it, if you are purchasing a dilapidated property that has been vandalized, and you are making a sneaky offer, or a cheeky offer, a cheeky offer to the seller, saying, yeah, this place, if you fix it, you're going to sell it for R1 million, or it's worth R1 million, and it has been vandalized, you can waive the condition that the seller does not have to deliver a certificate of compliance. Okay. The seller is usually to pay the rates, taxes, and levies. That is standard. The seller is liable for that, unless you are purchasing from other instances. But these are private offers now. If there is an estate agent involved, the seller usually pays the estate agent, unless, I don't want to say that. So lease agreement and vacant occupation. Remember, we spoke about this. Look at it, find it, ask for a copy. And if the seller says to you, no, there is an oral lease agreement, remember, an oral lease agreements can be orally. Those ones does not have to be in writing. So there can be oral lease agreement. Then I would stipulate those agreements, the agreement in the contract by saying the seller will hereby give notice to the tenant to vacate. Will give 30 days notice to the occupant or the tenant to vacate once guarantees has been delivered or the bond has been approved, which contract is on a month-to-month basis, something like that, that you can just record it, that you cannot turn around and say, yeah, but I told you I have to give 2 months notice. Okay. Disclosure of defects, we spoke about that. That is the footsteps. People, whatever you want to have repaired has to be in the contract. If it's not in the contract, it falls under the footstep clause if it was a visible defect. And then obviously your due diligence. Make sure that all conditions are stipulated in the agreement. Are you still following me? All right. So we are now going to talk about, okay, yeah, that is the different types of agreements. So let's talk about the more difficult ones. Repossessed properties. Those are PIPs, property in possession. So what type of properties are these? So these are the properties where the bank has purchased the property back on auction. Share of auction, maybe insolvencies as well, maybe deceased estates. It is the bank. Sometimes the banks, they do take transfer of the property. Sometimes they just hold it until they can resell it again, and then they do the simultaneous transfer into their name. So things that you have to look out for. So where do you find PIPs? There are platforms where you can find it. I think if you look on My Roof, there is a that says bank repossessed. You can look at those ones. When you apply on My Roof, they send you a basic terms and conditions thing for your offer, and then they've got a lengthy contract that they send you afterwards once they accept your basic terms and agreement. But this is what you have to look out for. Illegal occupants and defects. People, the bank is the seller. The bank is selling this property footsteps. They don't care who's in it, and they don't care how the property looks like. It's your responsibility as purchaser to make sure that you inspect the property. Who is occupying the property? Is it still the owner? Is it illegal occupants? Has the property been hijacked by illegal immigrants or people like that? People that has pluckers there. Okay, be mindful of that. People, to do an eviction is very expensive. You must budget for it. If you are willing to take it over, because you can make an offer and say, you know what, I'm willing to do this eviction. This is not a process. I know all these clever people that can help me, but it's going to cost me 30,000 Rand. So I'm making you an offer for 50,000 Rand less because I have to take care of the occupants. But be mindful of who is staying there and go and view the property. Or if it's a little bit far from you, build your relationship with estate agents in areas that you've got, that you can talk to them and say, listen, I'm interested in this property. Will you go and view the property for me? Take pictures, find out what's happening, build that relationship with this person that he can send you pictures if it's difficult for you to go and view the property. But make sure that you know what you're in for. So terms and conditions that you have to look out for with repossessed properties. Remember, who's selling it? It's the bank that is selling it. They are holding it. So is a deposit required? I'm telling you now, the banks usually, the moment that you sign an agreement, they might ask you to put down a deposit. Are you enforced to do that? Just tell them no. I don't want to put down a deposit. Let's see what they do. But look at the terms and conditions. Do they require a deposit? Do they have an option that you can apply for a bond? Make sure, because if there's not an option for a bond, people, then we are back to an unconditional contract now. At the top, unconditional contract, that means I'm purchasing your cash. But if you want to apply for a bond, or if you want to purchase this property with a bond, and this same will apply when we get to auctions, then you have to make sure that you have pre-qualified yourself, that you have made contact with our bond originators in our network here at the Property Academy, that they can pre-qualify and say to you, Choma, you are fine to go for 500,000. You can make offers up to 500,000. We just need to marry the contract with your pre-qualification. Then it will go through. But do not sign a contract if you have not pre-qualified yourself, especially if you're going to pay a deposit, because you're going to forfeit it then. Okay? Remember, if there's not an option for a bond, it's a cash deal, but you can marry it with a bond, but it will not be subject to you getting a bond. Then look at the time period to deliver guarantees. How much time do you have? Look at if there's any commission payable. Why do I have to look at that? Never assume that commission is part of the purchase price. Don't assume that. Read the contract. Is it payable by this? Is it included in the purchase price, payable by the seller, or is it payable over and above the purchase price? We will get to that at auctions. Look at what the contract reads. Does the bank guarantee vacant occupation? I don't think so. Just have a look. Maybe you're lucky. Maybe the bank says, or you will inquire, and they say, no, but the property is empty or whatever. Just remember that in some instances, and I know Nedbank does that, they've got guards there. They've got a gas alarm system, which is really very nice. So you can phone for access at those property, and then they can deactivate the gas alarm for you to get access to the property to view it. I know Nedbank does that. I don't know about the other banks. I haven't heard other banks do it, which is actually very cool. All right. Occupational rent, interest payable with prior occupation. So people, remember, we've got straightforward transactions, and then we've got these lot that we are going to talk about now. So make sure read the occupation clause. Sometimes, and I must say, I don't know why these people hasn't changed their contract up to date. They've got a contradiction clause that says that you will take occupation on the date of acceptance of the contract. And then there's another clause that says, should the purchaser elect to take occupation, then the following will take place. But basically what it says, just look at that clauses. Just scratch out the one that is in contravention of the other one. But I would rather do the one that says, should the purchaser take prior occupation prior to registration, then there's occupational rent payable. It's usually 1% of the purchase price. And they will not give you occupation until you've until you have, number one, delivered or given proof of delivered guarantees, signed, and paid your transfer cost. Okay. So one can maybe negotiate and say, listen, I've already got my bond. I've already proven you. I'm already on the road here. I see the property is being vandalized, or maybe that there's a security risk. Can I take occupation? Just know that you will be paying occupational rent or interest. Sometimes there is an automatic interest that's payable. Those are the contradiction clauses. Just have a look at it. Liability for rates, taxes, and levies. So in practice, the seller is liable for rates, taxes, and levies. But usually, these PIP contracts, they say the seller is liable until date of acceptance of this offer. And from that date on further, the purchaser is liable for rates, taxes, and levies. So the importance here is that you find that condition, look at those, and see what it stipulates. Unfortunately, you cannot really scratch it out. No, it's not for you to negotiate on. Sorry, nah, that is just how it is. That's life on these type of properties. But you have to make your calculations when you do make your offer. You must make provision, for example, for five months, for example, and just do it in your calculation, which will determine your offer. And under these circumstances, because I say the bank does not care how the property looks like who's staying there, the seller does not deliver any certificate. So that's why it's important that you go view the property to see, is it a vandalized property? Maybe all the copper cables has been stolen. So can I tell you a story? So I bought a property on an auction, sheriff auction, in that when it was the recession year, 2017, 2020. No, I'm lying, 2007 to 2010. And I bought a property there on a sheriff auction. And the property, I sent the estate agent out and he said, yo, this is very nice. Yo, everything looks good and we're going to sell it. Oh my gosh, people. When I sent out the electrician to do the certificate, he came back, he said to me, there are no wirings. I said, how's it possible? He says, no, all the wirings were ripped out of the property. They were ripped out. They just nicely put back all the switches. It was a shock. I had to rewire the whole house. So, yeah, that was a little bit of a dent. Luckily, it was a very small house. So, yeah, just make sure. Maybe test the electricity if you're there. Okay, so let's talk about private auction. So the previous one was repossessed. They are offers that you make directly to the bank, insolvency and stuff like that. But private auctions. So private auctions are usually held at the premises, which gives you the opportunity to inspect the property while you're there. They are sometimes also vacant, and you can, well, you will see when you're there what the situation is and so on. So in terms of the law, the auctioneer is compelled to read out the conditions prior to the auctions. But people, if you're not familiar with terms and conditions, it's going to go whoop over your head. All right? You can phone the auctioneer and just ask them to send you a copy of the contract for that property to be auctioned tomorrow. And just read through it, especially with these conditions that we are going to talk about. Who usually puts the property on private auction? So who's your seller going to be? It's usually deceased estate, insolvent estate, sometimes in divorced estates. There's actually sometimes a condition in the settlement agreement. Sometimes the owner that's going abroad that is immigrating and he has to sell it quickly, or also sometimes PRPs. They will disclose to you on the auction who the seller will be. So what to look out for? People, auctioneer's fee. I'm telling you now, if you are on the private auction, the auctioneer's fee, how do I say it's 50-50, but in most instances, it's over and above the purchase price. It's the purchaser's responsibility. Okay, so be mindful who's going to pay for that, because there's no use in bidding up to $1 million and you only had intention of purchasing it for $1 million and then you've got 100,000 plus VAT commission as well. So be mindful. Is VAT applicable? Not on the auctioneer's fees. There will be VAT on the auctioneer's fees in respect of the seller. They will disclose to you. Remember, if VAT is applicable, the problem is your selling price is usually plus VAT. If you are registered as a VAT vendor, then it's fine. Then you can claim it back, the VAT back against your VAT. But yeah, just be mindful that has an effect on your calculations. Is vacant occupation guarantee? So when you go and view the property, you will see whether there's people staying there. You can ask the auctioneer what's going to happen and stuff like that. Usually that is dealt with. Levies, rates and taxes, as I discussed in the previous session or the previous slide, who's going to pay for it, and are you liable for it from date of acceptance? Depending on who your seller is, people, if it's a deceased estate, insolvent estate might be, insolvent estate, they might say to you, you have to pay from date of acceptance. A personal deceased estate of a person that has passed away, and in divorced estate, the owner of a quick sale, you will most probably not be liable for any rates, taxes and levies as from acceptance. Interest on the purchase price pending registration, have a look at it, and then also is there the option for early occupation. All right, so private auctions, let's go. There's some other conditions that you have to look out for. Deposit, do they require deposit? Will you forfeit if you do not proceed? Oh, and yeah, does the seller deliver guarantees? Once again, depending on who my seller is. If it's a PRP, no certificates. If it's an insolvent estate, no certificates. If it's a deceased estate, if it's a divorce estate, if it is a, what was the other one that we said? If it is a owner for a quick sale, then certificate will be delivered. Find the clause, read it. The seller will not be liable for any defects. These people on auctions, there is no, it's foot to it. It's as is, eh? What you see is what you get. If there's any defects, you are purchasing it with those defects. So if you want, you must make it you must do your due diligence while you're there. Make your sums and say, okay, this looks bad, this looks bad. Okay, these people, this is about 50,000 of repair work. Okay, I have to bid for 50,000 less. All right. And auctions do not have suspensive conditions. There is not an option for you obtaining a bond. Why is that the case? It's the same with sheriff auctions, to which we are going to go now to, because it costs money to put properties on auction. Adverts that has to be placed. If you drive down the road, these poll ads, you've got the auctions being there, put up there, those costs money. So they cannot sell on auction subject to you obtaining a bond. All right? It costs too much money. It's a done deal. So if there's no suspensive conditions in respect of you getting a bond, so it is then an unconditional contract. If you do not comply, you can forfeit your deposit. You will definitely have to pay a deposit, yeah? But you will forfeit the deposit if you cannot proceed or perform in terms of the agreement. Once again, don't go to an auction if you intend to buy with a bond. You have to do pre-qualification that the bond originator can just marry the contract with your already pre-qualified application. Okay, just take note, with this type of auction, there's usually a time period for the seller to accept the auction, to accept the offer on the auction. I don't have enough time, but there's some snacks there too. Also, if a higher offer comes in, for example, they have to go back to you and hear from you, are you willing to raise your offer? Stuff like that happens. And after auction offers can be made. So I'm going to run out of time. So let's talk about auction, sale, and execution. These are sheriff sales. I do a lot of back-to-backs on sheriff sales. So sheriff sale conditions, they read 99% all the same. So these auctions are held at the sheriff's office. They are scheduled for certain times. You will know, if you start looking around, you will find that out. Your biggest problem with sheriff auction is the inspection of the property prior to auction. That is your problem. That is your challenge that you've got. So be now a clever person. Drive past the property and see how many estate agent boards are in front of it. Because why? Obviously, these people are in distress. COVID happened, life happened. These people were unable to pay their bond. The bank is foreclosed and the property is going on auction. Obviously, they tried to sell their property. Phone the estate agent whose board is in front there and say, Mrs. Estate Agent, I see you are, don't tell them you're going to buy this property on auction. Don't tell them that. I see that you've got a board in front of the house. How long has it been in the market? For what price has it been in the market? Why isn't it selling? Because it could be, obviously, they are overpricing it because they are in distress now. They want to see if they can get as much money to cover all the expenses. Why isn't it selling? What is the market value? Who's staying inside? Is there a tenant? Blah, blah, blah. All of that stuff. You all ask all of your questions. That is your base. What is the condition of the property? That is, ask that. Are there any defects that you know of? Okay, thank you very much. I will come back to you. Phone the other estate agents, ask the same questions, compare your notes. All right. There is a sheriff commission that is payable. It's actually, when I bought on sheriff auctions 10, 12 years ago, it was maximum 10,000. It's now already going up to 40,000. And you will pay a 10% deposit. It's a non-negotiable aspect. They will not go on to the next auction if you don't go into the cubicle and do your EFT there. Okay? And then you do have the risk of forfeiting your deposit should you not comply. Once again, I did not put in here. Oh, no, there I did put it. Okay, it's voetstoots. Okay, I'm not going to explain it. Terms and conditions to look out for, not that you need to look out for, because all of them are the same. Vacant occupation is not guaranteed. We've discussed this. Usually, I put here 30 days. I had a little bit of an argument with a sheriff attorney on Friday, and when I read that contract, it was 21 days to deliver guarantees. You will be liable for interest on the purchase price if you delay the transfer. Now, that is what my fight was about with the sheriff attorneys on Friday, because they asked me to pay the rates and taxes, which was a whopping 75,000, and I paid it 10 days later than what they requested, and the interest kicked in on the purchase price. So just be mindful that if there is interest on the purchase price, no certificates will be delivered. Those are the compliance certificates. And people, only on sheriff auctions, you will be liable for all arrears, rates, taxes, levies, homeowners. Okay? So when you make your offer, you must make sure that you know your sums. They do disclose amounts on auction, and then you can just plus another 10 or 15%, because by the time they draft the conditions, they obtain an outstanding amount, but it goes on auction like 3 months later. So it increases. So they do disclose these amounts, but that you must just do your sum backwards and find out. I mean, my one client bought a property for 10,000 Rand because the arrears levies was like 200. Okay. Then what's different on sheriff auctions are the risk of the property passes to you with the fall of the hammer. So you can, with your contract, go to the occupant and say, hello, I've just bought this property. Look, I've paid my commission, my deposit. Sorry, the risk has passed over to me. Who are you? And if you want to stay here, you must pay me rent, please. And then you can negotiate and negotiate. So sometimes it's a disgruntled owner staying there. Be nice, because they've been most probably through a difficult time, but rather negotiate and make war with these people. Otherwise, you have an eviction on your hands, okay? And once again, it's an unconditional contract. What does it mean, people? You cannot make it subject to a bond. You must have your finances in place. Oh, we're almost there now. So let's talk about back-to-back transactions. So what is a back-to-back transaction? This is not the intention of the Property Academy. It's for back-to-back, not necessarily. I don't know whether they touch on it, but the intention of the Property Academy is to help you to build your property portfolio by buying. But sometimes things happen that you have to sell it on for whatever reason. Maybe you cannot get your finances in place, then you rather sell it on. So there are two types of contracts with back-to-backs. So you can actually do a back-to-back on any type of offer that you've purchased. So I'm now squinching here because on insolvencies, they don't like it. There's actually a clause in the insolvency contracts when you make your offer to the curator of the insolvency state that says you are not entitled to sell the property on. But we still do, and we still manage it. As long as your sell on, do not delay the first. That's why you need me with my very convincing personality to talk to these attorneys and say, don't you worry, just get your stuff in order. I will be ready for you. So that's why they say they do not accept guarantees from third parties, but we've got a way to win it. We've got a way to talk to them. So here's what you have to look at. So you can do a back-to-back on any transaction. Let's now, if the fact is that if you do a private offer, you can have an exit clause. If you've got on private transactions now, you can have an exit clause of having a bond. If you are making an offer with the intention to resell it, maybe, then you must allow yourself enough time to perform. For example, you will give yourself not 30 calendar days to get a bond, but 30 business days to get a bond. Okay? And maybe if you want to renovate it, then you can request consent for renovation prior to registration. So this can also be done with sheriff auctions, because you get immediately risk passes to you on the day of the auction. So you can already, if you've paid it, you can get access. You can start doing renovations to sell it on. So don't get confused. In certain instances, it might take a little bit longer. So you've got your first transaction. But the important part is your selling of the property. So remember, when you sell it on, now, just remember with back-to-back transactions, we do not physically take transfer and then sell it on. It might happen that you have to, but under the normal circumstances, we have the contract here and then we sell it on. And when we put the two transactions together, and it goes together through the deeds office. Okay? So this is what you need to look out for. On your reselling, you are the seller now. Do not overpromise. Don't tell your purchaser that he can move in the 1st of July, but where you are purchasing on a private transaction, and now in our example now, the seller said to you, but there's a tenant and he can only vacate the 1st of August. Don't do that. Then rather put it here on the right, when you're selling on, you say you can occupy at registration. And then closer to the time, you can renegotiate an earlier occupation. Okay. On your reselling, you must allow shorter time period for compliance for bond applications. Okay? Because why? Because you've allocated yourself here 30 days, for example, on your private transaction, or if you've got a sheriff transaction that's running here and you are now pressed to sell it, don't give your buyer 30 days to get a bond, 7 days, 10 days to get a bond, okay? Because you have to get your contracts in as fast as possible. And yeah, and we're going to talk about other conditions as well. So just give them a short time period. If you don't get a bond, sorry to hear, there's another one in line. You must make it subject to the registration of the property into your name. That is one of the conditions that you have to put in. Why? Because if you do not put that clause, that specific clause in here that says this contract is subject to the registration of the property into the seller's name, then you are splitting the two transactions. Because now let's say something happens on the first transaction and it's cancelled. Then you're going to have consequences on this transaction. You cannot give transfer because you cannot get transfer. Then you're going to be liable for wasted cost and agent's commission if there was an agent involved. You must have it in. Include additional clauses for continuous marketing. We're going to talk about that. Include additional clauses for property to protect yourself against defects. So these are my clauses. This is my last slide, I think. Yes. Okay, so additional clauses for back-to-back. This offer is subject to the simultaneous transfer of the property into the seller's name. So sometimes it happens, I've got clients, they buy on sheriff auctions, they've got the money, they want to take transfer because they know they have to do a lot of renovations and then they're going to sell it on, maybe just rent it out for 6 months and sell it on. So, but then they pay the money and then they can take transfer. But sometimes it happens that he sells it quickly and it goes simultaneously. It's important to put this in. It is. It is recorded that the seller has never occupied the premises or the property and bears no knowledge of any latent or patent defect to the property. You don't know what is wrong with this property. Don't guarantee. Please don't guarantee, especially if you're selling it on by an estate agent and they've got a defect list. Don't know. Don't say, I guarantee the roof is good. I guarantee this. Please don't do that. You are going to be in for damages because you don't know what the condition is. Then you can say further, purchaser has examined the property and he will have no claim against the seller for any repair or damage to the property with a latent or patent. That is just to protect you. And then this clause is a scary clause. You have to be very brave, but you have to do this if you are speculating the property, buying and selling and buying and selling. So in law, there's the principle of first in time is first in right, which means also you can do it that way around. So the contract that's dated first is the first one in right. That's why you have to make a time period short. The second contract cannot be enforceable until the first contract has lapsed. Lapsed in the sense of did not get a bond. Okay? So you have to wait for the time period to run out before you can proceed with the second offer. So let's just talk about this clause. I'm going to first talk about this one that I'm talking about now. So let's say you have now forgotten to put in this very lengthy clause in. So what happens now is that first in time is first in right. So you've got your first offer. You did not complete this clause, so you have to wait it out. Now a second contract comes in. Nobody says you cannot accept the second contract. The second contract you will accept and say, this is a further, don't say second or third, this is a further contract and subject to the lapsing of all prior agreements. Then you'll have to wait it out in time. But then all other ones has to be accepted. So then if this one didn't have any clause, then this is your first contract. It has to lapse before you can go ahead with the second one. But the second one also, If you now remember, I would put in this one. If you did not remember, you would have put it in. This is a further contract and subject to lapse of the first one. And then this is a third contract or a further contract and subject to the lapsing of all prior ones. But then the date of the agreement determines the order of the contracts. Now, what we try to do, because we are going back to back and we don't have time for contracts to run out, we put in this very scary clause that says, pending the fulfillment of all suspensive conditions of this agreement, the seller shall be entitled to market the property and accept other offers. And then we sidestep the first in time, first in right that says, the seller shall be entitled to continue with the first offer of which all suspensive conditions have been fulfilled, notwithstanding the date of the agreement, and all other agreements shall automatically lapse and become null and void. The thing is, you have to put this clause in all your contracts. That is important. Okay, so people, that's me. Thank you very much for your time. I hope I have not confused you too much, and I hope I have enlightened you, that you've got more confidence when you read your contract, how to complete and look at contracts. Thank you.
Awesome. Thank you, Leonora. That was fantastic. And there are loads of questions in that chat box. So I'm hoping that you're going to help us manage those questions later on. But very, very exciting, lots of energy. So thank you for that, Leonora. Ladies and gents, was that good? Let me know in the chat box, was that a good session? Leonora, I can see that you just love OTPs.
Yes, Andrew, I do love it. I'm very passionate about it because I'm passionate about my work, and I'm also passionate about, you know, the type of transactions. This is not a normal transactions that we do, but what I've found is that the more the students know about the contracts, the less consequences we've got. And I just want to say that people, if you can grab onto the OTP course and get more familiar with contracts, do that. Do not, after 28 years, contracts comes automatically to me. It does not mean it's going to come automatically to you. Please grab on the OTP course, familiarize yourself, because then you've got more options and more, you are more confident in doing what you want to do.
I agree 100%, because that's the issue. Most people that do come along and that come to the offer to purchase, they get cold feet, they get bullied into signing someone else's OTP and don't understand. And Leonora, that's when they give you a call, and sometimes it's too late at that stage. Hence, get the education before and understand what you're getting yourself into. Know where to look in the OTP, because that'll give you more confidence and you're going to mitigate your risk. Would you agree?
Yes, absolutely. Absolutely. Andrew, you're correct.
Awesome. Thank you so much, Leonora, and we'll see you later on. If you're wondering what Leonora was talking about, literally like this week, we've just completed our next property course through the academy called the Offer to Purchase course, where we got Leonora, we've got Repossession on there. We've got a whole bunch of property investors, estate agents, talking around all the different type of offer to purchases. Remember that this course is included in option 1 and option 2 of the bundle package that we put together for you. Okay, fantastic. So what have we done so far? We've now covered the first 6 steps of the signature solution. So now we're at the point where you now understand how all the OTPs work, all the different types, what you can do, what you can't do, which is fantastic.